listen-only mode.
Hello, my name is Benjamin Lee, and I just want to welcome everyone. It is now 1 p.m., so we'll begin our presentation shortly. Today on November 15th, we'll have our presentation on ethical challenges for planning consultants. For help during today's webcast, please feel free to type your questions in the chat box found in the webinar toolbar to the right of your screen or call 1-800-263-6317. For content questions, please feel free to type those in the questions box and we'll be able to answer those after the presentation and during the presentation. Here is a list of the sponsoring chapters, divisions, and universities. I would like to thank all of the participating chapters, divisions, and universities for making these webcasts possible. These are the list of upcoming webcasts. To register for these upcoming webcasts, please visit utahapa.org/webcasts and register for your webcast of choice. We are now offering distance education webcasts to help you get your ethics or law credits before the end of the year. These webcasts are available to view at utahapa.org/webcast archive. To log your distance education CM credits, go to planning.org/CM, select Activities by Provider, select APA Ohio Chapter, then select Distance Education and select your webcast of choice. Follow us on Twitter, like us on Facebook, and we also upload recorded presentations on YouTube. To log your CM credits for attending today's webcast, please go to planning.org/CM, select today's date, November 15th, and then select today's webcast. This is available for 1.5 CM credit. We're recording today's webcast and it will be available along with a 6-slide per page PDF. Please email planningwebcast@yahoo.com for the presentation. And at this time, I would like to introduce KK, who will introduce our presentators for today.
Thank you, Ben. Welcome, everyone. We're going to switch over here and pull up today's PowerPoint presentation. And just at the beginning, I want to tell all of you, if you're listening to this and thinking, oh my gosh, I'm not a planning consultant, I'm not going to get anything out of this, I want to let you know that that's not actually the way we have it planned. So what we are hoping is that while this is planning ethics for planning consultants, but there will also be a lot that you can take away if you're not a planning consultant. If you've ever wondered how our brain works and what you need to know dealing with planning consultants, or if you've secretly harbored a desire to be a planning consultant, hopefully there'll be some things in here that appeal to you. And I also wanted to just give you a little history on this. This is something that has been an interesting subject for me for a while, and we are kind of building on a session that we had done previously where I was exploring whether there are different sets of ethics for private sector and public sector planners. And the conclusion that we reached at a session I did at the Indiana conference is no, it really is the same set of ethics. We really do look at it the same way. And I'm wondering now, all right, hopefully you can see this PowerPoint screen.
I could,
and
there we go.
There we go. All right. Let me just introduce my fellow participants today. Not sure why that took so long to pull up, folks. Sorry. Thanks for listening to me ramble. As Ben said, my name is KK Gerhard Fritz, and I am from Indianapolis, Indiana, where I am a consultant, a one-woman firm. Joining me today are folks from two other parts of the country. We have Holly Carolyn. Holly is from Las Vegas, Nevada, and has promised me that not everything that happens in Las Vegas has to stay in Las Vegas, but she will be talking a bit about some of her life as a planning consultant. Holly just retired last year, but had spent 28 years in the private sector as a planning consultant, and also had done 6 years in the public sector before she retired. So she's seen both sides, as have I. And Holly is, you will note, AICP, so we're really honored to have her as part of this, a long-time member of the Private Practice Division. Joining us is Jerry Weitz from North Carolina. And Jerry wears a couple different hats. He is the president of his own consulting firm, and he is an associate professor at East Carolina University. So he's also looked at ethics from different viewpoints before. And Jerry is also FAICP, and we are delighted to get together again and explore this issue. So because this is sponsored and was created originally by APA's Private Practice Division, just want to make a plug for you to join at least one division because it's a great way to network. If you have always thought about being a consultant, if you have considered wanting to find out more about economic development, working with the divisions is a great way to do it, and it's a great bargain, particularly for students and new professional members at only $10. Also wanted to repeat that this is a session that we had done previously at the 2012 APA National Conference in Los Angeles. So if you did count the ethics session from that national conference, the same session, you can't double count it. And I also just wanted to extend thanks to the person who got this going originally, and that was our acting chair for the Private Practice Division, Deborah Meyerson. And Deborah's contact information is up on the screen there should you want to volunteer for something with the Private Practice Division. She's always looking for volunteers and ways to get folks involved. So let's talk about our learning objectives for today. What we're going to do is really try to look at the standards that we have as planners, as certified planners for ethical behavior, and we look to our code of ethics for that. We're going to be highlighting parts of the code that we think are particularly relevant to situations that planning consultants find themselves in. Again, if you are not in the private sector, if you are in fact a public sector planner, again, you can kind of find out what kinds of things we face day to day. And then we're going to be looking at specific situations and look at those situations to kind of see what ethical issues and concerns might be raised in particular situation and how we would respond to those. And the other idea is that we all, again, kind of think about our reasoning and reflection skills, about how we can apply what we learn to our everyday ethics and what we encounter in our daily lives. So what we're going to do today is introduce, we've got 6 different situations, and then we're going to show you what we think is relevant to those scenarios based on the AICP code. And we're also going to each just say a couple words of each situation, and that should take about 4 to 5 minutes. Now, it might be helpful for those of you out there to go ahead and pull up a copy of the AICP Code of Ethics, just so that you can look through and see if you agree with what we're citing in the code. If you're like me, it always helps to have something in writing in front of me that I can look at. We will be putting the excerpts from the code on the screen, but again, you may just want to pull up a copy so you've got that in front of you. As far as the questions, what we're asking is that you submit written questions, and we will try to respond to those at the end of our presentation. So if you could be patient until we get through our scenarios, we've allowed plenty of time to work through your scenarios that you submitted questions. And we will try to do those in order, but some of them may be very similar, so we may be merging some of them together. so that's what we're looking at today. Definitely time to talk about your own ethical concerns and scenarios. So before we begin, just some background on the AICP code. All communications that occur with the AICP code should occur with APA's executive director, who is Paul Farmer. He is officially the ethics officer for our profession. And just some general advice that you just need to pay attention to what you do or say. And this piece of advice comes from Polly, as does the naked picture that we have on the screen here, which is basically you got to pay attention to anything that would make your sainted mother roll over in her grave, or that you or your children wouldn't want read about yourself in the newspaper or in social media. And I think we've all seen, especially with social media in recent years, some amazing things that pop up with ethics there. But, you know, generally it's a lot of common sense when we think about ethics. So, Polly, you want to talk about this naked picture that you have submitted here?
Well, he may be naked, but the book is appropriately placed, so one can't tell whether he might be entirely naked. And yes, that is my grandson, and my son tells me I can't use this after he turns 15, which he won't do for another 13 years.
All right, there you go. So the other thing we want to talk about is that in your own chapters you have professional development officers, and your PDO are people that you can go to at a more local level and talk about ethics with. They're not authorized to actually give you guidance, but they are good people to bounce things off of and to ask for some directions, like what part of the code do you think this might relate to the situation, or where do I go at national, that kind of thing. So you do have PDOs who can be resources for you. And then the other thing I think that I learned very quickly as a young planner, which has been many years ago now, is that ethical situations really aren't cut and dry. We've heard a lot lately about the bestseller 50 Shades of Gray, and I would be inclined to say there's probably more than 50 shades when it comes to ethical situations. And they're often just dependent on the point of view that you're seeing from, whether you've got all the information in front of you, all kinds of different things weigh into ethical situations. So keep that in mind as we talk about things today. And remember that the code is there to help you try to figure out these ethical, moral dilemmas that pop up before us. And remember also that the code has two different sections that we're going to talk about today. There's actually 4 sections altogether. Section A of the code is the section of aspirational things in the code. They're not technically enforceable, but we're all supposed to be trying to follow them. They need to be considered. And then Section B is our rules of conduct, and they are the section of the code that is enforceable. So today we'll be talking about Sections A and B of the code. So getting to our first scenario here, I am going to go ahead and pass this off to my friend Holly, and she's going to walk us through the moonlighting scenario.
Hi. I'll just read it out. A planner is employed by city government. He or she wants to do private consulting work in another nearby local government jurisdiction while maintaining the current public sector job. Can he or she engage in private work, and if so, under what circumstances and precautions? And this happens, you know, like it says on the slide, times are tough. Can we afford to turn down work? I think that's a good question. The next slide shows the parts of the code that are applicable to this. KK, if you could flip it for me, thanks. And it really depends a lot, first, on what your employer says. You need to go to your employer and make a full written disclosure of what you're going to be doing, who's going to furnish the funds, and this is all a proposal until you receive written permission to undertake that additional employer. And then also, if unless your employer has an express policy that you don't have to do that. But I would advise you still to go to your employer and be open about it, even though there is, he can't stop you, that employer still might want to have some input and might be able to give you some really good advice. And this boils down, even if it's in another jurisdiction, it may be that you're doing a lot of work for developer who is also working in your community, or for a consultant who's in line to do your comprehensive plan update. There's some of these things going on, and so you need to be careful about the appearance of conflict. And in that, I'll open it to other folks. It's only the one slide, is it, or is there another slide with the code provisions on it?
Just that one this time, Holly. So
Okay.
we'll go back to those.
Okay.
Barry, you want to pipe in? You haven't had a chance to say anything
Sure,
between
sure
Holly and I.
thing. Yeah. Hi, everybody. This is Jerry. In my view, you can engage in moonlighting as a public sector planner. You can engage in that work as long as you comply with the requirements of Rule B4, Rule of Conduct B4, which we've shown there. You should also examine whether there are any potential conflicts of interest between your city employer and the nearby locality. And one of the ways you can do that is by looking at the expected outcomes, as Polly indicated. Examine what the ethical issues are in terms of your consulting project and judge how they might intersect or interreact with the city's issues. And if you can identify conflicts, any conflicts, then you can try and mitigate those through or by preparing a conflict of interest management plan. A couple other things I would mention about this scenario is that, number one, jurisdiction may matter. So all nearby localities may not necessarily be the same. In other words, there might be some issues with one city that they work together a lot, or they're at loggerheads or something like that, where that may have a bearing on your decision on whether to participate in the consulting effort. Another thing you can do is write into your consulting contract with your indicating that you have a primary employer, the city, so that your consulting, your client knows that you have other obligations. And what is not on the slide here in terms of the relevant code provisions is the preamble of A2, which says we owe our diligent, creative, and competent performance of the work we do in pursuit of our client or employer's interests. So we obviously should never lose sight of the fact that we have a primary job. And a couple other things, like Polly indicated, check your city personnel policies, because they could tell you whether or not you're allowed to engage in that, despite what the AICP code says. And another one is, it should go without saying, but there may be a temptation to engage in some of that consulting work on city time, and of course that would be wholly inappropriate and unethical to do that. With that said, I'll turn it over to KK for her perspective on it.
Well, let me just say that, and let me tell you all that are listening, that these are all real-life scenarios. I don't think I mentioned that at the beginning. As we put together this presentation last spring for the conference in Los Angeles, we drew from our own experiences. And I spent half my career in the public sector and half of it in the private sector, with some teaching at a university thrown in there for good measure. And I actually have faced this kind of a scenario before, and I think the one thing that really is something I want to put forth is that you owe some allegiance to your primary employer. It's really important that you do not take something on that has the potential to drag that allegiance that you have to that employer, to that job down. And you need to carefully think about that. And as Jerry mentioned, I have some communities where I have worked where they are basically at war with their next door neighbor. Another community nearby, I have some that work very closely together and would see it as a plus if you were also working in an adjacent community. But I think you have to definitely not lose sight of that fact. And it's tough because being somebody who's been in the private sector, I've talked to a lot of young folks who have tried to set out and start consulting, and it's been really tough for them to think about turning down work, even if potentially, has some conflict out there, because they really need the work, they really need the money. But you need to think as planners, always don't lose sight of that big picture, the long-term impact that it could have. All right, good. Let's go on to our next scenario, and Jerry's going to introduce this one for us.
Sure, okay. This one's titled Public and Private Client Conflict, and you are a consulting planner under contract to prepare a zoning ordinance for a city, and you were on the city government planning staff a short time earlier. Now a developer has approached you and is intent on eventually upzoning a large parcel of land in the jurisdiction for which you are preparing the zoning ordinance. The developer asks you if you will take the developer on as a client and provide, quote, political advice about individual council members and how to proceed with getting the property upzoned. So what can you do under this scenario? And I'll go ahead and give my 2 cents worth. This one is rather involved. I think there are a number of different aspirational principles as well as several rules that could apply here. And we have up on the screen, next slide, KK.
Yep, working on. There we go.
Okay. Yeah, there's several aspirations that could be listed here. We've only listed one, which basically in terms of speaks to accepting the decision of your client. But then we go into more significantly the rules of conduct. So rule of conduct 3, which essentially is relating to changing your public position on an issue. That one could apply or not. And then let's go on to the next one.
All right.
We have 2 slides on this. And the other rules, several other rules potentially apply. Not on the screen is number 4, B4, and also rule of conduct number 7 regarding breach of confidentiality. And then also 13 and 14, where 13 relates to intentions to influence via improper means, and then 14 having to do with using your official power for a special advantage. So many, many different rules that could come into play potentially on this, but let me focus on, really there's 4, so I'll try and go quickly with this that I think are important. The first one is B3, where we can't accept an assignment from a client to publicly advocate a position on an issue that is adverse to something we had previously advocated. So this slide may not necessarily apply, but we've got to be clear whether we're touching on it or not. Now, in this case, the planner would be giving, quote, political advice and not representing the developer in front of the city. So with that said, I think it's a little bit different. I'm saying that it's very possible that one could engage in this activity, but there are serious and significant dangers that you might want to be aware of. Another one which was not on the slide was Rule of Conduct B4, and that relates to basically outside employment and moonlighting. It doesn't look like this would be applicable because you're a planning consultant, but really remember that this says this goes to the gaining permission and fully disclosing your activity. And even if this Rule B4 does not apply, it would be advisable to go to your city client and say, hey, this is what I'm thinking about doing. What do you think? Will you give me permission to do this? And then really decline the assignment if the city is uncomfortable with it. And they very well could be uncomfortable with it. A few other things. On the slide was also cited B7, which has to do with breach of confidentiality. This is probably not going to amount to a violation of confidentiality, but remember, this developer is interested in political advice, and that means you might be prone to observe or share with that developer certain things that, while not maybe confidential, the city council members might not want them to hear or have you articulate to them. So you need to be careful with B number 7 as well. And then I would mention number 13, which is on the slide there, ability to influence decisions by improper means. Now, it would be inappropriate for the consultant to in any way suggest to the developer that you could use your influence with council members, or even worse, that you would never want to use the code writing aspect of your job with the city in favor of that developer. It would have to be, of course, very clear that you were not ever going to be able to try and influence the code, the regulations, the zoning rules in favor of that developer, and you would need some kind of an agreement with the developer that said that. So if you work for the developer, write into your contract an agreement that you would not advocate on behalf of the developer, and that there's no expectation that your code work for the city would be done in any way to the developer's favor. And I know that's long-winded, so I'm going to stop there and turn it over, I guess, to Polly for her response.
Yeah, I think you summarized it very well. I think the only other thing I might add to it is I'm seeing this giganto can of worms. If you take that job, even if you have written agreements with both clients, it's the appearance of conflict of interest that could damage your reputation. I figure I've got two things. I've got my health and my reputation when it comes to work. And this kind of activity, I think, could damage your reputation whether or not you have these agreements, because there might be an appearance that you would be working for the developer in constructing the ordinance to the developer's advantage, even though you wouldn't. Now, KK, what do you think?
Yeah, I think that's a pretty good insight. I like what Polly said, that she's got her health and her reputation, because at the end of the day, we do need to be able to look in the mirror and feel comfortable with what we see looking back at us. And I think that, for me, is always a good bottom line. One of the things that I wanted to talk about on this one is coming at it slightly different. And if we look at Rule of Conduct number 13 over here, it says we shall not sell or offer to sell services by stating or implying an ability to influence decisions by improper means. However, most of us as consultants are trying to sell our services and are trying to show that there is an advantage to hiring us. And so what we do is try to, we're able to be hired, and we're often hired to try to influence decisions. The key is there that we're trying to do it by proper means, not improper means. So there's a real big difference in what consultants should do and what the code warns us against, and it's this improper meetings, which I think gets to the heart of this matter. So I think that was a big difference that I wanted to touch on there. The other thing, going back here and looking at this scenario, as I mentioned that, you know, I worked in the public sector, and in fact worked in the public sector first before I went to the private sector. And one of the things that I made a conscious decision to do when I did go out on my own was I just decided that I would not take on my former employers as clients for a certain number of years, nor would I take on anyone who wanted to be represented to my former employers. And that's something that I just did for my own peace of mind and my own comfort level. Now, that's not to say that, you know, when I started doing this, the economy was in better shape, and so I had the ability to say pass occasionally, which I know a lot of you who are trying to get firms started right now may not have that luxury of saying, I'm not comfortable getting in this situation right now. But, you know, that's a thought. Again, it's going back to the I've got to be comfortable looking in the mirror at the end of the day with what I've done and who I am and the ethics that I have. And so that's just another thought on maybe how to handle some of those, particularly if you've had a relationship with a city planning department, county planning department, and are stepping into the private sector also. Any other thoughts, Jerry or Polly?
Well, maybe one quick one just to confirm what you said, KK, that I think one of the biggest issues here is rule of conduct number B13, and that is if you in any way suggest or imply an ability to influence the city's code writing process, that to me would look like a pretty clear violation of rule of conduct number 13 as well as probably number 11.
Right.
Okay.
Right. Okay. Good discussion, folks. All right. I'm going to go ahead and walk us through this one. And let me just start out by saying that my best friend is an attorney, so we spend a lot of time kidding each other about her profession and my profession. So I do this with love for attorneys, so don't send me a bunch of messages about that. Okay, so in this scenario, we are looking at someone who's a consulting planner. They work for city planning department, and they're a zoning administrator. The city attorney is a real estate attorney, so they have a background in real estate, which is better than some of the attorneys we work with who write wills by day and then come and represent the planning commission by night. But this planner has observed that the city attorney frequently has some private real estate clients, and that when there is a conflict between what those clients want and the city, the attorney will choose the interest of his client to the detriment of the city. And he is also, again, charged with representing the city. So the city attorney has a lot of political connections in the government. That's probably how he got appointed to that position. We are concerned that he would retaliate if this planner raises the issue publicly. Now, you are a certified planner. You are witnessing this activity. What do you do? Well, I think right off, again, we have to go back to the heart of the matter, and that is that we owe allegiance to our employer, and that our allegiance needs to be consistent with our service to the public interest as part of that. Those are underlying huge issues as far as the ethics code, and that's allegiance to our employer, allegiance to the public. We also need to make sure that we don't accept an assignment where we know that there's going to be some kind of conduct that's questionable, illegal, in violation of some rules, and we need to make sure that we disclose the interests of our clients or employers. And we shouldn't be participating in any kind of effort to cover up, in this case, what the attorney is doing for their own employer. Now, with that being said, as far as the attorney's ethics, the attorneys have their own code of ethics, and it's not the same as what the planner's code is, and I don't know the details of what their code of ethics is. But we can't apply our planning code of ethics to that attorney. He's not governed by the AICP code of ethics. However, we are as planners. So what we as planners do is what we need to be concerned about with this. How do we react to it? Okay, so what do we do in that situation? And I am going to go back to Jerry and ask him for his reaction to this situation.
Sure. Okay. Well, there is an obligation on this planner's part to speak up for the city's interests, in my opinion. What the city attorney is doing in this case is either unethical conflict of interest, at least related to the AICP code, and it may also be actually against the law. So if you believe that it is in the public interest that the city not be hurt by the city's attorney's conflict, then the rule of conduct B2 would apply, and KK, you pointed that out, which is that we shall not accept an assignment from a client or employer when the services involve conduct that we know to be illegal or in violation of these rules. So even though KK is correct that the attorney does not have to follow the AICP code, if you recognize that there is a code, then we're limited by Rule B2 not to accept that assignment. Now, here's one of the issues, though, is how literally do we read Rule of Conduct B2, because we're not really in a position of accepting or not accepting an assignment. We're already in that assignment, and so the issue becomes, do we continue with that assignment? And this is one where it really is a tough choice, because going back to Rule of Conduct 19, it appears to make a requirement that you, in essence, blow the whistle on the city attorney, or that you either end the client-consultant relationship or you blow the whistle on the city attorney, because the ethical planner must disclose the interest of the city and how they are being violated by the city's own attorney. So that's Rule B19, that we shall not fail to disclose the interests of our client when participating in the planning process. So I think KK's right to note Rules B2 and B19 that are the really clear ones that apply here. And so in summary, because it's so difficult of a situation, what I'm suggesting is either you maybe decline the assignment, quit working for that city, or you really have no other choice but to blow the whistle or be silent. And this is a case where the choices are so extreme that ethics may actually not prevail in this case. But one further thing I would suggest is you can always at least talk to the city manager about it and let them know how you feel and what your concerns are. And in my view, there's a good argument to be made that you would discontinue work on this or even blow the whistle on the city attorney, but that's such a difficult thing to do given that you would face retaliation or the likelihood thereof.
All right. Good thoughts. Polly?
Yeah, I'm of the opinion that sitting down with the city manager would make a tremendous amount of sense, and simply say to the city manager, this is an impossible situation for me because I see this going on, and I can't continue to involve myself in the process. So essentially, if you need to know what your city attorney's doing, and then your reaction to what the city attorney is doing will determine whether or not I can continue to be of service to this community.
I like it.
Yep. A couple of things I want to jump in and just talk about for a minute is how would we answer this question differently if the planner that we were talking about was not AICP? We're assuming that that planner that's part of this, that's witnessing this, is governed by the AICP code. So let's say it's someone who's not AICP. Would it matter? And would they react differently because they're not covered by a code? And I think that's something we need to think about. And let me just remind you that there is a set of ethics that APA has for everyone who participates in the planning process. So even if you're non-AICP, you are still going to be covered in a voluntary kind of manner by the AICP code. So simply being non-AICP, I don't think gives you an out on this. The other thing that I think that this really brings to the forefront is that there is a huge difference between something being unethical and illegal, and that we often have those things that might be going on. So there's often, you know, what does the law say? And I think it was Jerry that raised the idea that it could very well be something illegal. That could be a state law or it could be a local law. And so you need to be aware of what those laws are in addition to our code of ethics. But those are two separate things. So don't forget that something could be legal but still be unethical, or could be ethical, however, could be illegal. So don't mix those two things up in your mind, because they are really very different things. All right, good discussion. Let's move on to Polly and our next scenario.
Oh, and this is one that happens all the time. I get very frustrated between that and the amount of funding that's available for a project. The city's request for proposal asks for a local comprehensive plan, and it specifies that the plan is to be prepared within a 6-month time frame. You know the review process alone will take 4 months, leaving you only 2 months to accomplish the public participation tasks and prepare the plan. You viewed it as impossible to undertake in that time frame. However, you know that other planning consultants are likely to bid on the project, in so doing, so suggest it can be done in the time frame, even if they know they cannot. What does your firm do? Well, if we flip to the next slide, it's absolutely, we don't solicit clients or employment through the use of false or misleading claims, harassment, or duress. And false or misleading claims is just neon. Here I am in Vegas talking neon, just like the Strip. Hey, don't tell a client that you can do work that you can't do in the time that's specified by the client. And that's whether it's a fee or a pro bono, and I'm doing some of that pro bono work now. So you just can't do that, even though you will be undercut by your competition. If your client has a memory, if your potential client has a memory, they will remember that firm X said they could do it, but then they had to go back and redo the contract, so it took a year, and then they really were more like 2 years before they finished the job. And they'll remember that they were told one thing at the beginning and then had to redo the contract as they went along. Again, that's just a perfect way of making your firm look bad from just a financial perspective, but also you are lying when you say you can do it, and that simply is contrary to the rules of conduct and should not be done. That's all I can say. I have to say this is a hot button for me. Jerry? Thoughts?
Yeah. This is most consultants have experienced something of this sort in their career, and I would say under the current circumstance as given to you that your firm should not bid on the contract, but I would not leave it there. I would not stop there. But let's observe that we do have these two rules of conduct, number 11 and number 16, and I agree with Polly that clearly any sort of, if you know the work cannot be done in the time frame and you somehow apply for the job, put in a proposal saying that you can, you really have pretty directly violated both of these rules. And another one that's not on the slide is B12, which says we shall not misstate our education, experience, training, or any other facts which are relevant to our professional qualifications. So arguably you do this job the way it is now and you violated 2, maybe 3 different rules of conduct. But rather than say, okay, I'm going to be ethical and therefore I'm going to lose this job, I'm just not going to be able to apply, I would not give up on it. What I would do is I would contact the procurement officer who issued the request for proposal and raise the issue in writing along with my own concern that the work cannot be undertaken within that specific time frame, and then I would ask for an extension of the schedule. That way, if the RFP is amended by addendum, then and it provides a better workable time frame for completion of the work, then I would bid on it. If the time frame was not extended, then I think, again, you would violate especially Rule B16 to the extent that you are misstating your facts by saying you could do the work within the time frame when you know clearly that you can't. But there's still a rub out there. You know, to be ethical, you may lose the job, and you look at what other consultants may be doing, and not all other consultants are AICP, and so they may not care what the code says, or there could be AICP members who will bid on this project even knowing that the time frame is unrealistic, but what they're banking on is the idea that when they get the contract, they'll immediately turn around and ask for a change order and extend the time period. And at that time, the project manager is probably more receptive. They understand the project better and its constraints and time frames, and they'll say, oh, yeah, sure, we'll go ahead and revise that time frame now because we realize it's going to actually take us longer. Well, the ethical planner is not going to do that. They're going to try and get it extended up front, and if it's not, then let this project go. If you can get it extended, then go ahead and bid on the project. That's my view.
All right. As someone who has a one-woman firm, I have been hit with this one many times and have been asked to do something with what looks like an impossible calendar. And sometimes when those RFPs would come out initially, I would look at it and I would say, there's no way I can accomplish something like that, so I'm not even going to respond. And then I learned eventually that competitors were still responding to it, and I figured out that I would do basically what Jerry was just saying, that when I get a situation like this which has something that looks like it doesn't have enough time with it, that I go back to the planning firm, the public sector planning office, whoever issues it, and talk to them about the time frame. But then the other thing that I've also learned is that sometimes what you initially view as impossible is not necessarily impossible, it's just somewhat unusual. So that it is possible sometimes to do a comprehensive plan in, in a certain number of months that is not normally done if you are willing and you've got the commitment to work under a very heightened, condensed calendar, and you're willing to work weekends and evenings, and you've got commitments from your clients, and you've got very high level of public input, and I've been able to pull some of those off in the past. So I guess I would say is don't just dismiss it out of hand, but like Jerry had said, go back and say, I really think it might take more time, or if we do this isn't normal. We'd have to do this, condense that, and do that to make it work. So don't necessarily give up on it, but definitely give some thought to what they're trying to accomplish and talk to the agency about it. All right.
Yeah, I would second that motion, and I might also suggest that maybe the client doesn't think the review process period is included in the time to prepare the plan. And so it would be worthwhile going through the RFP in detail with the client to be sure that first of all, you can't extend the time, and secondly, that you have perceived the time period correctly.
All right, very good. Jerry, you want to walk us through our next scenario?
Sure, I'd be glad to. Number 5 here is called disadvantaged group input, and you are a planning consultant with a contract to prepare, excuse me, a plan for a county, and also a separate contract to prepare a plan for a city, which is in the same county. You, the consultant, find that the elected officials of the city are not inclined to seek input from a low-income, disadvantaged, disproportionately African-American neighborhood. An opportunity arises for you to meet with that neighborhood, and it will be a meeting in which the press is there with the tape, videotape, and television. The consultant, you do not want to ask the city if you should attend because you're afraid that the city is likely to say no. So what do you do as a planning consultant in this case? And if we go to the next slide, we'll see that there are several aspirational principles here, as well as one rule that apply. We've got 3 slides here. So the first one, basically, we have to provide timely and accurate information on planning issues to all affected persons. That principle could apply. Then there's A1E, which we have to give people the opportunity for meaningful impact, and that participation should be broad enough to include those who lack formal influence, which could apply to this neighborhood. Then there's some others. Let's see what we've got here. A2, the preamble to A2, as well as A2A. Well, I missed A1F. That's clearly an important one. Seek social justice, give people, expand the opportunity for people to participate in plans and recognize the needs of disadvantaged, and specifically to promote racial and economic integration. And then we must urge the alteration of policies that oppose such needs. Then if you look at Principle 2, we owe diligent performance of work to our client. However, it has to be consistent with our faithful service to the public interest. So we're setting up a conflict here between public interest and certain aspirations in the code versus our allegiance to our employer. If we go on to the 3rd slide, there's one rule that applies here, as well as some other principles. I think A2A is also in particular important, that you have to exercise independent professional judgment. And again, going back to your employer's decisions, we have to accept those unless they're inconsistent with the public interest. So do we ditch our loyalty to the client and go ahead, although they haven't really told us don't go meet with the neighborhood, but that's our sense, that's our fear, is that they'll say don't bother doing that if you ask them, so you have not asked them. So then let me mention Rule 19, and this is a tough one because is it really applicable? Read it carefully and say, well, it may not be. It says that we shall not fail to disclose the interests of our client or employer when participating. Well, I don't think we're going to go out and say that our client we think is racist. That's not what this means, I don't think. We don't want to disclose the interests of our employer in that regard. But to get to where or how I would handle it, I'd say that I would attend the session. I would go ahead and meet with the neighborhood, and that this situation does not appear to have any rules of conduct that would be violated if you attend that. But then, yet there's multiple principles in Section A of the code that do apply. And the residents of the neighborhood are low income, they're disadvantaged, mostly African American, and they deserve the opportunity to have meaningful impact on the planning process. And we also need to observe and pursue social justice. And so I would try and get creative somehow, and note in this scenario that the city, you have a city client and a county client. Well, get creative and suggest maybe if the city ever said, well, why did you go to that meeting when you didn't ask us our permission to do it? You could always say, well, I'm here as a county representative, because you do have a client who is the county and the city is in the county, so you can argue if you had to as a defense that you were doing the work for the county. It's a little bit sneaky. I call it creative. You might even, others might call it deceptive, but it's really up to you to decide. Okay, and with that, I guess, whose turn is it, Polly or KK? KK, why don't you go? You lead in on number 6, the next one.
Okay. Sure thing. I just wanted to go back to this slide because I don't know how many of you noticed the photo that slide had, but I love that illustration. And I am from Indianapolis. That was something that was put in as part of the Super Bowl art that we did this past year. So kind of a fun slide there that I think is relevant to us. Okay, back to the topic. I think that I would probably look at it very similar to what Jerry said, is that we know that that you've got one contract with the city, one contract with the county, so you're trying to balance those interests already. And you know the right thing to do is to get input from this neighborhood. And you know that if you get that input, somebody's going to find out that you were there because it's being taped, it's being televised, it's going to be news, it's going to be loud. So you know if you ask, someone's going to say no. What do? Well, let me tell you, I have still one child at home who is a teenager, and this is an approach that is often used by my teen. If I ask, I know that she will say no. So it's better not to ask Mom or Dad and to go ahead and do it and then suffer the consequences. And I would have to say that in this case, I would probably do the same thing that my teenager would do, and that is to go ahead and do what I, again, know the right thing to be and risk that censure by one client and hope that they will understand that or accept that I'm representing the other client. Because, again, we've got back to some of the underlying things of what this code of ethics is about, and it is making sure that we really are letting people really have a say in what happens. And I think public input is one of the huge, huge cornerstones of this code of ethics, and we have to give people a chance to have meaningful impact. So I'm very much a person who does a lot of consulting with the public input piece of things. And it's often my job to sit down with the elected officials and say, yes, I know this neighborhood's going to be frustrated. It's going to be a difficult meeting. They're going to be unhappy. But you have to have this meeting. You have to have that input. You can't not have that input. You can't ignore that neighborhood, that part of the city, because they have an norm, the more unhappy that neighborhood becomes. So I often am the proponent of saying that you need to invite everyone to the table, even the difficult people, the noisy people, the people that others don't agree with, because if you ignore them and then wait till later and it comes out in the newspaper or comes out on a news story on television or something, then everything really blows up. So I am often battling kind of an uphill battle to try to get folks to buy into the fact that they need input from everyone. And it's not always an easy thing to do, but again, I think it's a real cornerstone of this code that we have. All right, Holly.
One of the things I like to do, and I think you've touched on it, KK, is to initially sit down with a client and talk about how public input is really valuable, that we can really learn something through that process. And if we don't get the full range of public input, then we've limited our ability to know what's going on in the city and to be able to do a good plan. These people, you know, there's some thought that they don't have anything to tell us. Well, it's my experience, and one of the reasons you hired me is my experience, that these people do have something to say to us, and that we would benefit from that. And I also agree that there's some real benefit in asking for forgiveness rather than permission if you know you're going to get a no. The other thing is some of it depends on your contract. If your time and materials contract, even if it's not to exceed, if it's time and materials and you charge to go to something your client doesn't want you to go to, then maybe you need to be willing to take that financial hit. And so you can go back to the client and say, well, you know, I'm a human being. I get to, I'm a citizen. I get to go to the meeting and listen to what's going on, and I didn't charge you for it. Therefore, I was there as a private citizen and bring that knowledge back, even though you didn't give me permission to go. So now I'll ask for forgiveness.
Yeah,
I hope that's
Polly, I think that's a very good point to make, and that is that if the city client came back to you and said, well, I saw you attended this meeting and you didn't ask us to go, and are you charging us for that, then I think you would have to legitimately say, well, no, since I didn't, that's on my own time. I think you have to be prepared to, like you said, eat those costs as a consultant for your choice.
Yeah, good point.
Yeah, and but you're also benefiting and maybe saving some money all the way down the line by not having to go through as hostile a review period as you might if you had initially taken that input.
Good.
All right, very good discussion, folks. All right, we're going to go on to our last scenario that we have, and by the way, we've got a lot of questions that are coming through, so we've got some good discussion. Be prepared for that. Our last scenario that we have for you today concerns affordable housing. And in this scenario, you are a planner who's working on a comprehensive plan for a city. The mayor has been in office forever. He's like the lifetime mayor, and he has indicated that property owners in an older in-town neighborhood want the property rezoned from single family to office use. And the city planner on the city planning director, let's say, indicates that the land use plan should be changed for this neighborhood to go ahead and show office use for the mayor. Now, you know, because of your research, that this is mostly a rental neighborhood. It is still stable, but it is adjacent to downtown commercial. And you also know that it's one of the few remaining neighborhoods in the city that provides affordable housing for low-income persons. Let's just really mix that up and say that that even though it's own single-family residential now, that includes what some might consider multifamily, like condos or accessory apartments or duplexes or something like that. And that it is something that people really know they can find something affordable in that neighborhood, but there's not many other places in that city where it's possible. So you're the planning consultant, you're working on this comprehensive plan, you've been told by your client, hey, the mayor says let's change this from residential to office use, just go ahead and make it office use. What do you do in that situation? Well, back to what we were talking about in the last scenario, a lot of those same things that we talked about probably apply. If we look back here, that the social justice idea, that we want to expand choice and opportunity for all persons, and that we need to promote economic integration, that's affordability. So are we going to be working on something or doing something, changing this map so that there's no longer any affordable housing neighborhood in this whole community? One of the other things that we want to look at is that, again, while we owe this allegiance to our clients, we also have to make sure that we provide faithful service to the public interest or to the public. So for me, I probably quite honestly face this situation every time I do a comprehensive plan in a community. It seems like, particularly if we start talking about multifamily, even low-density multifamily, it's something that is very unpopular in communities in Indiana where I work. And I am always in the situation where I have to sit down and work with the elected officials, other local representatives to really talk about the idea of what would happen if we change this, what would happen if there was suddenly no affordable housing in your community. And it often becomes an opportunity for education with that client. And so again, we're down to this idea that the public interest in doing what's right may not be the easiest thing always. It may cause you to have to sit down with your client and say, look, folks, we've got to offer more choices, more affordability in housing, and here are the reasons why we want to do it, and do some education as part of that. And again, it's something that I face all the time, and I think it would be irresponsible of me as a professional planner to just go ahead and automatically change that category on the land use map without really talking it through with my client. Okay, Jerry or Polly, want to jump in there?
Polly, you want to go ahead?
Yeah, I guess I would be also looking for some blending, if you will, because if the neighborhood is really turning over, people are going to start using their houses for work purposes, that it would be, you really need to work closely with what's happening in the neighborhood and then try to do something that would, if you can't manage to convince your client that needs to stay residential, that you need to do something to compensate for, to make sure that there are really more, when all is said and done, more opportunities for affordable housing in the community. If that makes sense, Jerry?
Yeah, it does, and it actually is probably a better answer than I was going to give, because I wasn't going to go that far, but I appreciate your suggestion that if this neighborhood turns over to office, then you could even cite an obligation on the city's part to provide some compensatory housing somewhere else, some other policy that would make up for the loss of affordable housing. But to give you my perspective on it, it's pretty much the same as what you've heard, and that is that the ethical planner is going to recognize that this is an opportunity to advance social justice, and that in this scenario we know the mayor is inclined to reclassify the neighborhood for office, and it is debatable, but it's also appears to be justifiable in at least in part. So as KK had said, before I just agreed to acquiesce to what the mayor said and what the planner suggested that I do, the city planner, I think it at minimum should be brought to the mayor's attention the goals of the city and other affordable housing for low-income households. And we should also note as planners the policy implications of changing that neighborhood from residential to office and the impact that will have on affordable housing. So I would definitely outline my concerns, but in the end, I would be inclined to accept the mayor's decision as the client. Of course, the mayor himself is not the client. The client is more broadly the mayor and city council. So you could argue, well, I want to talk to the whole council about this issue. But after being elected for 30 years, one would anticipate that the mayor can carry the day if it came to the city council. So I think that would be not wise to try and argue that case with the city council. And then I would just tack on to that what Polly said, a great suggestion, which is what can we do to compensate for the loss of this neighborhood, because it is an important loss here. Okay.
Well, and could we go back to the last situation where we have a meeting with the people in that area and ask them what they think?
Sure.
They might
why
come
not?
back to us and say, hey, I've been offered 5 times what I paid for this house. If I get that money, I can go buy something else somewhere else, and I'd be happy to leave. And so we don't know. We don't know what they're thinking if we don't go to them and talk to them.
All right. Good. Well, Polly and Jerry, we've got some good questions and comments that have come across. So let's spend the remainder of our time discussing some of these. The first one I'm going to throw out to you is going back to a comment on the appearance of the conflict of interest, that we should not even engage in something that would give the appearance of having a conflict. And one comment that we got was, you know, there's always going to be somebody who's going to be looking for a conflict and seeing something when it's not there. Should there be some kind of a qualifier? You know, if we really try to hold that to the highest standard, somebody's always going to perceive that there's something going on that really isn't. How far do we take that?
Yeah, I'd like to chime in on that one. I think that's a very good observation. When you say avoid a conflict of interest or even the appearance of is an incredibly high standard to accommodate. And even in the scenarios that we've discussed here today, if you applied the standard that by all means you can't do anything that will become an appearance of a conflict, then that would solve the answer one way or the other. You would never do anything of the sort that we've even said could be acceptable today. So I think that there is the modifier to me is being able to mitigate that conflict. And admittedly, this is not in the rule, but because the rule says avoid the appearance. But if you can avoid that conflict by addressing what would come up, and you have a plan that would manage whatever scenario came up, then I think, in my own view, that's good enough to meet this aspirational principle.
Okay, good. Polly, you want to say anything on that?
Yeah, I think I would agree with that as well. That if you could resolve that in some way, and then make sure that everyone involved is aware of how that arrangement has been made to avoid that conflict, I think that works beautifully, because then you're in a position where you have better knowledge and you might be actually more valuable to the process.
All right, good. We also had a question that is kind of an interesting situation where someone says, what do I do when I'm in a situation where I work for a consultant and my boss is telling me to bill the time on one job to another job? What do I do in that situation? And
that's one of my very favorites.
Yeah, okay, go for it, Ms. Polly.
Well, first of all, it depends on what the job is. If it's federal funding, sorry, you can go to jail for doing that. I mean, you need to tell your boss that, because that's called fraud. And it is at least the appearance of doing something bad, and should not be done, period, amen, hallelujah.
Yeah, and I've actually been in that situation at, one point in time or other over my career, and the person that was telling me to do it was not a planner, I will say that. But I told them the same thing that Polly said is, not only is that unethical, it's illegal. So I think that's a very dangerous situation that you get into there.
Yeah, I would only add just rule of conduct B1 and B2, illegal or unethical conduct, and also inaccurate information and untruthfulness. These sounds like violations of rules of conduct to me.
Yep. We had another interesting question, and this I think goes back to something that I had said earlier about if you worked for the public sector and then you leave to work in the private sector, how long should you wait before they can be a client of yours? And didn't there used to be something in the code that addressed that? And
I can.
Yeah, I was going to say, yeah, there used to be something. We used to have something that addressed that, and when the code was revised several years ago, that time frame was taken out because there was the concern that it would be too limiting on people in areas where there wasn't a high number of planners and a high number of opportunities there. So, and correct me if I'm wrong, Polly and Jerry, but as I recall it, that was the reason that was taken out of the AICP. Rule of thumb is probably a year, but it really needs to be what you're comfortable with. And it depends on your situation, too. Jerry, why don't you go ahead? I know you had something there.
Oh, well, yeah, I do remember that was it was either a code provision or it was what they call an advisory ruling. I think it was actually a code provision, but it didn't survive when the code was rewritten in 2005, and I don't know as much as you do, KK, about how that got changed.
Well, just having faced that recently, having retired from the Regional Transportation Commission, I was involved in the RFQ process for them, ranking consultants. So I figure it's my responsibility not to go to any of the consultants that I supported or didn't in that process, because then I'm on both sides of that equation. And since it's a 2-year process, I'm figuring that I need to wait through that before I contact any of these consultants who have worked, who were selected because of my recommendations. And that's going to get hokey if somebody calls me. It would be, is this something that specifically is RTC work? So that would be a whole other question. But I do think that there are instances where you really do need to hang around and not do anything for a while.
Yeah, and I think we probably all are saying about the same thing on that one. We had another listener who sent us a note and said, in what situation should we be telling our clients that we have a code of ethics that we're supposed to be following? Is it something we should do with every job, or is it something that we don't pull out until we see an ethical situation popping up? And I'm curious as to how you both have handled that as consultants in the past, and assuming then, you know, that our client might be elected officials or a community that doesn't have a planner on staff, that doesn't know about the AICP Code of Ethics.
Yeah, I'll take a shot at that, answering that one. I think, you know, you have two basic choices, and one is to be proactive or to be reactive. And I think as far as what I've done as a consultant, I don't think I've been proactive enough, and I have tended to be reactive and only raise issues of ethics if they came up. But I don't think that's really necessarily the smartest thing to do. In fact, I would advocate, for example, in your contracts, you could have an ethics statement of ethics in your contract. Have it added as an addendum that you are an AICP member, and as such you're bound to, you owe diligence to employers and so on and so forth, and go ahead and put that in there. And the other thing you can do, which goes back to our first couple of scenarios, which is if you anticipate a conflict of interest, in order to head that off at the pass, so to speak, you could have some kind of statement about potential conflicts and try and address them up front before they happen. So the lesson is be more proactive if you can.
Okay, good. Here's a few other ones that we've gotten. I've got one person who said, what do we do in a situation where we are competing against competitors who are being unrealistic and almost to the point of lying in their proposal? Do we inform the client that our competitor is lying and that they can't possibly do what they're saying they should do?
Wow.
And so, yeah. Now, I will jump in there and say I think you have to kind of see what it is that they're saying in the proposal. If they are doing something that you clearly feel is a violation of our AICP Code of Ethics, and they are AICP planners, then I think clearly it is covered by the code, and it's something that you need to probably have a conversation with Paul Farmer about and get some advice on how to handle it. But if it's, let's say that you are competing for a project against a firm or a team that's made up of an architect, an engineer, and an attorney that aren't governed by the same code, then you've got a slightly different situation on their hands. And I think you also have to be careful how you talk to your client. I don't think you can assume that you know more than your clients. You know, your client hopefully has picked up on the difference between the different proposals and how dramatically different they are. You might politely give them a heads up and say, I really feel like this would not be something that you could do well in that amount of time, for example. So you want to be able to raise the issue with your client doing it, and without blackening someone's name, because you don't want to accuse someone falsely if you don't have all the facts in front of you too. So you really need to do your homework on this one, I think. Holly or Jerry, want to add anything to that?
Sure. I would say, as I agree with KK, that the better avenue would be to see if there is a if they are AICP members and you believe this strongly and you have the proof, you can go that route. As to informing the client, my first impulse is just that they would probably consider it whining, and it would be difficult for you to prove that they were lying. So I would be a little reluctant with a situation of this sort.
I would agree with that, and I'd suggest that if this is the kind of thing that happens regularly, that you use your proposal to explain what you're doing for the price more carefully, or the time period, so that the client understands the breadth of what's being offered, and that it may be substantially better than what is being proposed by the other firms, and that then the client can use that knowledge to evaluate the proposals. The trick is sometimes you're in a position where you got to take the low bidder. Jurisdictions are getting away from that, but if that's still the situation, then this is happening to you. You need to think about how you're going to respond to future RFPs from this jurisdiction, whether it's a good use of your time.
Okay, good. I think we've got just a couple minutes left. Let me make sure that we cover some other information for you real quick, and then we may have time for one more scenario. Again, I think you all hopefully know where to find the AICP Code of Ethics. Also want to point out to you that if you're interested in more, that there is a toolkit that AICP has, and we certainly encourage you to look into that toolkit, and also into a really good book that Carol Barrett wrote some years ago. And I suppose Carol is probably an ethics mentor for many of us out there. And it's got some great scenarios in there if you want to take a look at that, and that's Everyday Ethics for Practicing Planners. I'm going to pop up our contact information if you want to follow up with Jerry or Polly or I after this. And then the last thing that I'm going to throw out for our final scenario today is I've got one person who said, where I work is very much a pay-to-play kind of place. You're expected to make political contributions if you want to be on the list for RFPs and RFQs. If you want to be able to operate, you're expected to do this. Is that ethical, to make those political contributions? Jerry, Polly?
Oh gosh, that's a hard one. I don't know that it's unethical if you elect to participate in that situation, but I don't like it. I think you could stand on principle and say basically that political contributions are not. I mean, isn't that a violation of what's that federal statute? Anyway, I don't like it. I wouldn't do it. That's all I can say about it.
Yeah, I
have the same reaction.
Yeah. I will tell you, as a sole proprietor and someone who doesn't have a whole lot of overhead money for those kind of things, is I just tend to avoid working in those communities. I know who they are. I know what they want, and I can't afford the price that it would take. So I guess I save myself an ethical conundrum because I can't afford to take part in it. But I know that is a very real consideration, and that is something that does happen, and in some states it's worse than others. I suppose the one thing you could do is you could say, okay, I'm going to give money to both sides and equally support them, or you could simply say, I feel like I have a sit down and a discussion with them and say, ethically, I just don't feel like I can do this. And you may never see another RFP, but that just may be the way it is. So sometimes, I guess what I would say, sometimes what you have to do is not the easy thing. Sometimes it's not the most profitable thing. But at the end of the day, again, you've got to be able to look yourself in the mirror and feel comfortable with who you are. And like Polly said, at the end of the day, you've got your reputation. And that is very much what this is. The AICP Code of Ethics are here to help us with that, I think, is to help us keep that in mind and keep it in life. Polly, Jerry, any closing thoughts?
No, just good job, and it was a lot of fun.
Yeah.
Thanks for including me.
Yeah, I second that motion.
All right. Thank you all very much for participating today. And again, Polly and Jerry and I are available if you've got questions. Again, don't forget about your resource of your chapter PDO and Paul Farmer at National to resolve those big ethical issues.
Oh, hey,
Then,
KK, one last thing. I know we didn't get to a lot of the questions, and I don't know if we have any way to preserve those and share those or not, at least among the speakers. I would love to be able to see all of those questions that came in if that can be copied off of the webcast. I don't know if that's possible or not. We can ask Ben later about that.
Yeah, I can save the questions and send it to you guys.
Oh, that'd be great. If you don't mind doing that, then we might be able to follow up with people if we want to.
Okay.
Sounds good. Thank you.
All right, thanks.
Thank you, everyone.